Senator Brown.
Thank you, Mr Acting Deputy President. I rise to speak on the Human Rights Legislation Amendment Bill 2017, and in doing so I wish to acknowledge Senator Reynolds as a member of the Human Rights Commission committee that inquired into particularly 18C and 18D. And having said that, she would be well aware that there was no recommendation from that committee report that suggested that there should be a change to 18C. She knows that. She was a part of the committee inquiring into the report. She also mentioned, Senator Reynolds also mentioned the fact that people aren't talking about 18C. Of course, her own colleague, Mr Barnaby Joyce, has indicated to his colleagues and to the wider community that people aren't going up to him and saying, well, you have to do something about 18C. So what Senator Reynolds says to us here today is that if you ask a different question, if you ask a question about freedom of speech, you will get a different response. And I'm sure you would. I'm sure you would. Mr Joyce is not backwards in coming forward, you know. I think everyone in Australia would probably agree with that. But if you ask the question, do you believe that we need protections to protect people from race hate? I believe, overwhelmingly, Australians would say yes, because they're not a racist country, and that's not what we're saying here. We are saying that the protections are in the bill, they're in the Act already. We are saying that 18C and 18D, which provides the exemptions, that was glossed over by Senator Reynolds, is the balance that we need. That is what the Labor Party says, and of course the inquiry, as I've already indicated, found no basis to make this change. And what is even more galling, Mr Acting Deputy President, is that the announcement of these changes were made on Harmony Day. I mean, seriously, give me a break. Couldn't you have done something a bit better than that? You know, we waited over a year to get a response to the violence, abuse and neglect into people with disability, and you responded within days to the inquiry into the Racial Discrimination Act and on Harmony Day. You really, the Prime Minister really should be ashamed. So this bill is about the Prime Minister, Mr Turnbull, selling his soul to keep his job. It's about the Prime Minister being forced into a position where he now says to the Australian people that the racist hate speech is okay, simply to satisfy ideologues in his own party and his accomplices in One Nation. It's a sad state of affairs we find ourselves in. As has been repeatedly stated by senior government frontbenchers, including, as I've already indicated, the Deputy Prime Minister, Mr Joyce, and the Minister for International Development and the Pacific, Senator Ferranti Wells, the changes in this bill are not in any way a priority for Australians, and we will in fact hurt the government in ethnic communities. So where is the priority? The priority is in their own caucus room, and that is no way to run a government. The bill changes the wording of Section 18C of the Racial Discrimination Act by removing the words offend, insult, humiliate and replacing them with the word harass. There is no basis for this change, no logical reason why this should be done. This is an act that has served us well for over 40 years. It is one of the greatest gifts bestowed upon the Australian people by the Whitlam Labor government. It has stood the test of time as a hallmark of the values we as a multicultural society hold. In this country, we don't believe that people should be offended. We don't believe that people should be insulted or humiliated simply on the basis of their racial or ethnic background. That is plainly wrong. And yet, that is entirely the consequence of what this bill authorises. The bill also creates a new objective standard for determining a breach of Section 18C that does not allow courts to take into account the perspectives of minority groups. It's unbelievable, completely unbelievable. This is a deliberate weakening of protections against racial hate speech and racial discrimination. It's an absolute disgrace. This amendment is in fact a profound statement of what this government really stands for, what its modus operandi is. Mr Acting Deputy President, the Senate must stand as the last line of defence from the government deliberately intent on inflicting harm on Australians from a minority background. Labor won the fight to protect Australia's laws against racial discrimination in 2014, and we will do it again. Of course, this government has repeatedly failed to answer the simple question. And I'm sure, in fact, I've heard Senator McKim ask this simple question. Just what does the government want Australians to be able to say that they can't already under the existing law? Well, despite the government's decision not to answer this question, we know the answer to the question. We know the answer because a friend of the hard right in the Liberal Party and no friend of Mr Turnbull, Mr Andrew Bolt, told us. Andrew Bolt has told us the truth. A truth the Prime Minister and his government have tried not to mention. The proposed changes to Section 18C will allow more racial hate speech in Australia. According to Mr Bolt, a person will have to be insulted on the basis of their race 5 times before they could fall under the government's definition of harassment. 5 times to be insulted. Is that the acceptable standard that this government really wants to set? Apparently so. Well, Labor believes that to be harassed just once on the grounds of race is not good enough, that to be offended, to be insulted, to be intimidated or humiliated just once is not good enough. There can be no defence for racist hate speech. And the Australian people, Mr Acting Deputy President, agree. Just today, we've seen polling in the Fairfax papers to back this up. The Fairfax Ipsos poll has found that an overwhelming majority of Australians oppose legalising speech that offends, insults or humiliates on the basis of race. The poll of about 1,400 voters show that 78% of Australians believe it should be unlawful to offend, insult or humiliate someone on the basis of their race. Even 76% of respondents who intended to vote for the coalition said they support retaining the words offend, insult and humiliate in the Racial Discrimination Act. And we know the number of Australians who say they intend to vote for the coalition, of course, is dwindling. Well, it's no wonder. when they are so intent, when the government is so intent on ignoring the advice of their own ministers in pursuit of wacky ideological changes that are simply not on the radar of most Australians. Yet, for some Australians, these changes will have a deeply profound impact. And I want you to think about this. I want government senators to think about this. Mr Acting Deputy President, I want to quote from the Australian of the Year finalist, Mr Dean Adul, from the page 1 story in today's Sydney Morning Herald, because I think this is a particularly pertinent passage. The article says, and I quote, Australian of the Year finalist Dean Adul, a former South Sudanese child soldier who arrived in Australia as a refugee, said he was deeply concerned about the proposals. It's outrageous the Senate is thinking about doing this. This will be giving a free ticket to racism and telling the whole world we don't care about minorities. He said he did not believe coalition MPs understood how damaging racist speech could be. He said, and I quote, in Australia, politicians live very comfortable lives. They aren't the ones on the receiving end of racism. Racism reduces you to a lesser being, and that's what this legislation is about. It's psychological pain, psychological injury. It holds people down, end quote. You know, I ask government senators to let that sink in, to have a think about those words. It holds people down. It's psychological pain. It's psychological injury. That is the legacy Mr Turnbull wants to leave from his time in office as Prime Minister. Racist hate speech. That is the gift that Mr Turnbull wants to give to Australians. How can this government seriously condone what they are doing to our minority communities in this amendment? Really, it is deeply disturbing. Legal experts have agreed the government's changes to 18C will significantly weaken the existing protections against racist hate speech. We know that ethnic and legal groups, including the Human Rights Commission, the Law Council of Australia and the Human Rights Law Centre, have raised serious concerns over this bill. The Attorney-General, Senator Brandis, can make ludicrous and erroneous references to free speech and Voltaire all he wants. But the fact is, this bill has nothing to do with political correctness. It has everything to do with deliberately targeting and singling out minority ethnic communities to make them feel less safe in their home, in their country. It is detrimental to individuals and to communities. With this bill, this government is directly promoting racist hate speech in Australia. The Attorney and the Prime Minister cannot crab walk away from this damning and inconvenient truth. Let us not forget that the government chose to announce, as I've said earlier, these changes on Harmony Day, the International Day for the Elimination of Racial Discrimination. Well, that's a sickening twist, if ever there was one. As they walk the tightrope of views in their own shattered and divided party room, the government has sought to bring this bill on without a proper debate. They've limited just to a few days the time available for a Senate inquiry. They deliberately excluded First Australians, unbelievably but true, excluded the First Australians through the Aboriginal Legal Service from making adequate representations to that inquiry. A government-dominated Senate inquiry didn't call any Indigenous witnesses. Well, some respect for our First Australians shown there. For the government to exclude Aboriginal and Torres Strait Islander Australians from having a say on legislation that directly affects their ability not to suffer from racist abuse in their own country is an absolute disgrace. And isn't it interesting, Mr Deputy President, Acting Deputy President, Isn't it interesting that the government has chosen to introduce this bill first into the Senate rather than the other place? Because the government believes this bill will be voted down in this place. It's all designed to stop them from suffering an embarrassing and humiliating defeat on the floor of the other place, where they cannot be confident their own members will support their position. That's how deeply divided this mob over there are. This bill has pitted members representing diverse community against members and senators with an ideological obsession with Section 18C, and it's entirely unwarranted, entirely unfounded. The court has already interpreted 18C so that it only applies to profound and serious effects, not to be likened to mere slights. The discussion within the government on this made-up issue of freedom of speech and political correctness continues to ignore completely the subsequent section in the Act, Section 18D, the section which provides relevant exemptions. It states that Section 18C does not render unlawful anyone said or done reasonably and in good faith in the performance, exhibition or distribution of artistic work, or in the course of any statement, publication, discussion or debate made or held for any genuine academic, artistic or scientific purpose or any other genuine purpose in the public interest, or in making or publishing a fair and accurate report of any event or matter of interest, or a fair comment on any event or matter of public interest if the comment is an expression of a genuine belief held by the person making the comment. At the Senate committee inquiry held on Friday, Mr Harry Opperman, Vice Chair of the Canberra Interfaith Forum, said the current provisions of 18D would have excluded the late cartoonist Mr Bill Leak from any prosecution at all. And I quote from the Guardian Australian article titled "Ethnic Minority and Legal Groups Concerned Over Racial Discrimination Act Changes," published on Friday the 24th of March. Opperman said not a single person of his mother's family, his father's family or their circle of friends survived the Holocaust. Both of my families were murdered in their entirety, he told Liberal Senator Fawcett. I know of no ethnic cleansing, massacre or genocide which has ever prevented my good speech." End quote. Mr Acting Deputy President, there is a broad coalition of opposition to the amendment from ethnic and religious minorities across Australia, the people who will be most affected by this change. We should heed their call. Not the siren songs of free speech and political correctness emanating from the Institute of Public Affairs, One Nation and half the Liberal Party room. Frankly, the Prime Minister should have heeded their calls too. He should be standing with our diverse and multicultural communities. Instead, he's turned their back on them. He's turned his back on them. He's decided to side with One Nation and their leader, Senator Hanson. They've morphed into the one. They're one and the same. One Nation and the Liberal Party. The Prime Minister and Senator Hanson. Well, Labor won't abandon fundamental Australian values. We won't abandon the bedrock principles of the society we've built. Where we encourage and respect diversity, we will stand with multicultural communities. We will stand with persecuted minorities. Labor will not support changes to the Racial Discrimination Act, deliberately designed to make life harder for Australians from minority backgrounds. Mr Acting Deputy President, this bill also makes a number of changes to the complaints handling process of the Australian Human Rights Commission. A number of these changes have been poorly drafted and rushed through without adequate consultation. That goes to part of the reason that Labor tried to allow more time to deal with this matter earlier by moving a suspension of standing orders. It's disappointing that the motion was voted down, because the proposed changes put forward by the government would result in additional red tape, additional delay and additional costs for parties to complaints. They will impede access to justice. Amendments to this bill must be made to ensure that the poorly conceived changes to the complaints handling procedures must put forward by the government do not create new problems. That is why these issues need to be considered properly and orderly, not in a rushed manner designed to stem the bleeding from a politically wounded minister. The Senate should draw to a close this act, draw to the close this tawdry debate, end the hand-wringing over 18C
Brown,
and
your
vote to
time
protect
has
the rights of Australia.
Senator Siewert.